482.2. A specific start card is printed for each well drilling approval and is furnished by the state engineer to the applicant or the well owner. The start card is pre-printed with the water right or non-production well number, owner name and address, and the approved location of the well. The state engineer marks the approved well drilling activity on the card. If a start card is stamped with special conditions, the licensee shall contact the state engineer's office to determine what the special drilling conditions or limitations are, then implement them in the drilling and construction of the well. The licensee must put the following information on the card: A. The date on which work on the well will start. B. The projected completion date of the work. C. The well driller's license number. D. The licensed well driller's signature. 4.2.3. When a single authorization is given to drill wells at more than one point of diversion, a start card shall be submitted for each location to be drilled. 4.2.4. Following the submittal of a start card, if the actual start date of the drilling activity is postponed beyond the date identified on the start card, the licensed driller must notify the state engineer of the new start date. 4.25. A start card is not required to abandon a well. However, before commencing well abandonment work, the driller shall notify the state engineer by telephone, by facsimile, or by email of the proposed abandonment work. The notice must include the location of the well. The notice should also include the water right or non-production well number associated with the well and the well owner if that information is available. 4.2.6. A start card or pre-notification is not required to perform pump installation and repair work on a well. 655.4.4. Administrative requirements and general procedures. 4.3. General requirements during construction. 4.3.1. The well driller or pump installer shall have the required penal bond continually in effect during the term of the license, otherwise the license will become inactive. 4.3.2. The well driller's or pump installer's license number or company name exactly as shown on the license must be prominently displayed on each well drilling rig or pump rig operated under the license. If the company name is changed, the licensee must immediately inform the state engineer of the change in writing. 4.3.3. A licensed well driller or a registered drill rig operator must be at the well site when the following aspects of well construction are in process: advancing the borehole, setting casing and screen, placing a filter pack, constructing a surface seal, or similar activities involved with well deepening, renovation, repair, cleaning, developing, testing, disinfecting, capping, pitless installation or abandoning. All registered drill rig operators working under a well driller's license must be employees of the well driller and must use equipment either owned by or leased by the licensed well driller. 4.3.3.1. A licensed pump installer or a registered pump rig operator must be at the well site when the following aspects of pump work are in process: pump removal, pump installation, modification to the wellhead including capping, sealing, and pitless adapter or unit installation, or similar activities on and within the well involving pump installation or repair. Inasmuch as a licensed pump installer is allowed to clean, develop, test, and disinfect a regulated well, these activities must be performed in the presence of a licensed pump installer or registered pump rig operator. All registered pump rig operators working under a pump installer's license must be employees of the pump installer and must use equipment either owned by or leased by the licensed pump installer. 4.3.3.2. A registered drill rig operator who is left in responsible charge of advancing the borehole, setting casing and screen, placing a filter pack, constructing a surface seal or similar activities involved with well deepening, renovation, repair, cleaning, developing, testing, disinfecting, capping, pitless installation or abandoning, must have a working knowledge of the minimum construction standards and the proper operation of the drilling rig. The licensed well driller is responsible to ensure that a registered operator is adequately trained to meet these requirements. 4.3.3.3. A registered pump rig operator who is left in responsible charge of pump installation or repair must have a working knowledge of the minimum construction standards and the proper operation of the pump rig. The licensed well driller or pump installer is responsible to ensure that a registered operator is adequately trained to meet these requirements. 4.3.4. State engineer provisions for issuing cease and desist orders, also known as red tags R 655.4.4. R 655.4.4. Administrative requirements and general procedures. 4.3.4.1. Construction standards. The state engineer or staff of the Division of Water Rights may order that regulated work on a well cease if a field inspection reveals that the construction does not meet the minimum construction standards to the extent that the public interest might be adversely affected. 4.3.4.2. Licensed drilling method. A cease work order may also be issued if the well driller is not licensed for the drilling method being used for the well construction. 4.3.4.3. Incompetent registered operator. If, during a field inspection by the staff of the Division of Water Rights, it is determined that a registered operator in responsible charge does not meet these requirements, a state engineer's red tag, in accordance with subsection R 655.4.3, shall be placed on the drilling rig or pump rig, and the drilling or pump operation shall be ordered to shut down. The order to cease work shall remain effective until a qualified person is available to perform the work. 4.3.4.4. No licensee or registered operator on site, if, during a field inspection by the staff of the Division of Water Rights, it is determined that neither a licensee or registered operator are on site when regulated well activity is occurring, the state engineer may order regulated well work to cease. 4.3.4. General. The state engineer's order shall be in the form of a red tag which shall be attached to the drilling rig or pump rig. A letter from the state engineer shall be sent to the licensee to explain the sections of this rule that were violated. The letter shall also explain the requirements that must be met before the order can be lifted. 4.3.4.6. A licensee may appeal a cease and desist order by 4.3.4.6.1. Submitting to the Division a written statement clearly and concisely stating the specific disputed facts, the supporting facts, and the relief sought. Or 4.3.4.6.2. Requesting a hearing on the issue according to section R 655.4.7. 4.3.4.7. A cease and desist order shall remain in force during the pendency of the appeal. According to Section 5. When required by the state engineer, the well driller or registered operator shall take lithologic samples at the specified intervals and submit them in the bags provided by the state engineer. 4.3.6. A copy of the effective Rule R-655-4 should be available at each well construction site for review by the construction personnel. Licensed well drillers or pump installers and registered operators must have proof of licensure or registration with them on site during regulated well activity. 4.3.7. Before starting construction of a new well, the licensed driller shall investigate and become familiar with the drilling conditions, geology of potential aquifers and overlying materials, anticipated water quality problems, and no contaminated water-bearing zones that may be encountered in the area of the proposed drilling activity. 4.4. Removing drill rig from well site. 4.4.1. A well driller shall not remove the drill rig from a well site unless the well drilling activity is properly completed or abandoned, in accordance with the construction standards in sections R-655-4-9 through R-655-4-12. 4.4.2. For this rule, the regulated work on a well will be considered completed when the well driller removes the drilling rig from the well site. The regulated pump work on a well will be considered completed when the pump installer removes the pump rig from the well site. 4.4.3. The well driller may request a variance from the state engineer to remove a drill rig from a well before completion or abandonment. This request must be in written form to the state engineer. The written request must provide justification for leaving the well incomplete or unabandoned, and show how the well will be temporarily abandoned, as provided in section R-655-414, and must give the date when the well driller plans to continue work to either complete the well or permanently abandon it. 4.5. Official well driller's report. 4.5.1. Within 30 days of the completion of regulated work on any well, the licensee shall file an official well log with the state engineer. The blank well log form will be mailed to the licensee upon receipt of the information on the start card, as described in subsection R-655-4.4. 4.5.2. The water right number or non-production well number, owner name and address, and the approved location of the well will be pre-printed on the blank well log provided to the well driller. The driller shall verify this information and make any necessary changes on the well log before submittal. The state engineer will mark the approved activity such as new, replace, repair, deepen on the well log. The driller must provide the following information on the well log. A. The start and completion date of work on the well. B. The nature of use for the well such as domestic, irrigation, stock watering, commercial, municipal, provisional, monitor, cathodic protection, or heat pump. C. The borehole diameter, depth interval, drilling method and drilling fluids utilized to drill the well. D. The lithologic log of the well based on strata samples taken from the borehole as drilling progresses. E. Static water level information to include date of measurement, static level, measurement method, reference point, artesian flow and pressure, and water temperature. F. The size, type, description, joint type, and depth intervals of casing, screen, and perforations. G. A description of the filter pack, surface and interval seal material, and packers used in the well along with necessary related information, such as the depth interval, quantity, and mix ratio. H. A description of the finished wellhead configuration. I. The date and method of well development. J. The date, method, yield, drawdown, and elapsed time of a well yield test. K. A description of pumping equipment, if available. L. Other comments pertinent to the well activity completed. M. The well driller's statement to include the driller name, license number, signature, and date. 4.5.3% Accuracy and completeness of the submitted well log are required. Of particular importance is the lithologic section that should accurately reflect the geologic strata penetrated during the drilling process. Sample identification must be logged in the field as the borehole advances, and the information transferred to the well log form for submission to the state engineer. 4.5.4 An amended well log shall be submitted by the licensee if it becomes known that the original report contained inaccurate or incorrect information, or if the original report requires supplemental data or information. Any amended well log must be accompanied by a written statement, signed and dated by the licensee, attesting to the circumstances and the reasons for submitting the amended well log. 4.6 Official well abandonment reports. When a well driller is contracted to replace an existing well under state engineer's approval, it shall be the responsibility of the well driller to inform the well owner that it is required by law to permanently abandon the old well in accordance with section R-655-414. 4.6.2 Within 30 days of the completion of abandonment work on any well, the driller shall file an abandonment log with the state engineer. The blank abandonment log will be mailed to the licensed well driller upon notice to the state engineer of the start of abandonment work, as described in subsection R-655-4.4. 4.6.3 The water right number or non-production well number, owner name and address, and the well location if available, will be pre-printed on the blank abandonment log provided to the well driller. The driller shall verify this information and make any necessary changes on the abandonment log before submitting the log. The driller must provide the following information on the abandonment log. A. Existing well construction information. B. Date of abandonment. C. Reason for abandonment. R-655-4.4. R-655-4.4. Administrative requirements and general procedures. D. A description of the abandonment method. E. A description of the abandonment materials including depth intervals, material type, quantity, and mix ratio. F. Replacement well information if applicable. G. The well driller's statement to include the driller name, license number, signature, and date. 4.6.4 When a well is replaced and the well owner will not allow the driller to abandon the existing well, the driller must briefly explain the situation on the abandonment form and submit the form to the state engineer within 30 days of completion of the replacement well. 4.7 Official pump installation report. 4.7.1 Soon after the completion of regulated pump work on any well, the licensee shall file an official pump log with the state engineer. If well disinfection is the only activity on a well, a pump log need not be filed with the state engineer. Blank pump log forms will be available to the licensee at any division office, requested by mail or downloaded from the division's website. 4.7.2 Pertinent information to be included on the pump log by the licensee shall consist of A. The water right number or non-production well number. B. The well owner name and address. C. The approved point of diversion or location of the well. D. The start and completion date of work on the well. E. The nature of use for the well, such as domestic, irrigation, stock watering, commercial, municipal, provisional, monitor, cathodic protection, and heat pump. F. Pertinent well details including casing diameters and depths, total well depth, well intake depth intervals, wellhead configuration including pitless adapter or unit configuration if applicable. G. A detailed description of pump-related work performed on or in the well including pump setting depth, pump type, pumping rate, valving, drop piping, jointing, capping, testing, sealing, disinfection, and pitless adapter or unit installation. And H. Static water level information, to include date of measurement, static level, measurement method, reference point, artesian flow and pressure, and water temperature. I. A description of the finished wellhead configuration. J. The date, method, yield, drawdown, and elapsed time of a well yield test. K. Other comments pertinent to the well activity completed. And M. The pump installer's statement to include the licensee name, license number, administrative requirements and general procedures, signature, and date. 4.8. Incomplete or incorrectly completed reports. An incomplete log or a log that has not been completed correctly will be returned to the licensee to be completed or corrected. The log will not be considered filed with the state engineer until it is complete and correct. 4.9. Extensions of time. The well driller may request an extension of time for filing the well log if there are circumstances that prevent the driller from obtaining the necessary information before the expiration of the 30 days. The extension request must be submitted in writing before the end of the 30-day period. 4.10. Late well logs, lapsed license. All outstanding well logs or abandonment logs shall be properly submitted to the state engineer before the lapsing of a license. A person with a lapsed license who has failed to submit all logs within 90 days of lapsing will be subject to the state engineer's enforcement powers under Section 73(2)25 and Rule R-655-14, R-655-44. Administrative Rule Infractions. 5.1. List of infractions and points. Licensed well drillers who commit the infractions listed in Table 1 shall have assessed against their well drilling record the number of points assigned to the infraction. Table 1. Level 1 Infractions of Administrative Requirements. Table 1 Level 1 Infractions of Administrative Requirements. Infraction points: well log submitted late, 10 failure to submit a pump log, 10 well abandonment report submitted, 10 late license number or company name not 10 clearly posted on well drilling rig or pump rig, failing to notify the state engineer of a 10% change in the well licensee's company name, failure to properly notify the state 20 engineer before the proposed start date shown on the start card, failure to properly notify the state 20 engineer before the abandonment of a regulated well, failure to notify the state engineer of a 50% change of start date constructing a replacement well further 50 than 150 feet from the original well without the authorization of an approved change application. Failure to drill at the state engineer 50 approved location as identified on the start card, removing the well drilling rig from the 50 R-655-45 well site before completing the well or temporarily or permanently abandoning the well. Administrative Rule Infractions. Table 2. Level 2 Infractions of Administrative Requirements. Table 2 Level 2 Infractions of Administrative Requirements. Infraction points: employing an operator who is not 75% registered with the state, contracting out work to an 75% unlicensed driller, using the unlicensed driller's rig, without written approval from the state, performing any well drilling activity 100, without valid authorization, except in emergency situations, intentionally making a material 100% misstatement of fact in an official log or amended log. Table 3. Level 2 Infractions of Construction Standards Conditions. Table 3 Infractions of Construction Standards and Conditions. Infraction points. Approvals, 30. Using a method of drilling not listed on the well driller's license, failing to comply with any conditions. 50% included on the well approval, such as minimum or maximum depths, specified location of perforations, performing any well construction 100 activity in violation of a red tag cease work order, casing 30% failure to extend well casing at least 18 above ground, failure to install casing in accordance 50 R-655 to 4-5. With this rule, level 3rd Administrative Rule Infractions. Failure to install a protective casing 50 around a PVC well at the surface, using improper casing joints 100, using or trying to use substandard well 100 casing surface seals 100, using improper products or procedures to install a surface seal, failure to seal off artesian flow on the 100% outside of casing, failure to install surface seal to 100% adequate depth based on formation type, failure to install interval seals to 100% eliminate aquifer commingling or cross-contamination, well abandonment 100, using improper procedures to abandon a well, using improper products to abandon a 100% well, construction fluids 40%, using water of unacceptable quality in the well drilling operation, using an unacceptable mud pit 40%, failure to use treated or disinfected 40% water for drilling processes, using improper circulation materials or 100 drilling chemicals, filter or gravel packs and formation 40 stabilizers, failure to disinfect filter pack, failure to install filter pack properly, 75% failure to install formation stabilizer, 75% according to standard well completion, 30% failure to make well accessible to water level or pressure head measurements, failure to install casing annular seals, 30% cap and valving, and to control artesian flow, failure to disinfect a well upon 40 R-655, 4-5. Completion of well drilling activity. Administrative Rule Infractions. Failure to install sanitary well capping according to standard, failure to install a pitless adapter or unit, according to standard, failure to develop and test a well, according to standard, failure to hydrofracture a well, according to standard, failure to install packers or plugs, according to standard, failure to install well intakes, including screens, perforations, and open bottoms, according to standard, failure to install non-production wells, according to standard, pump installation and repair, failure to extend well casing at least 18 above ground, failure to make well accessible to water level or pressure head measurements, failure to install casing annular seals, cap and valving, and to control artesian flow, failure to disinfect a well upon completion of pump activity, failure to install a protective casing around a PVC well at the surface, failure to maintain surface completion and security standards, failure to install or maintain backflow protection, failure to develop and test a well according to standard, failure to install sanitary well capping according to standard, failure to install a pitless adapter or unit according to standard, failure to prevent contamination from entering a well through placement, products, tools and materials, failure to repair a well's surface seal, 7575, 7575 75 surface seal, 75 70 30, 130 30 30 40 40 40, 655, 45, to securely cover an unattended well during construction, failure to engage in well drilling activity in accordance with accepted industry practices. Administrative Table 4, Level 4 Infractions of Application Requirements. Table 4, Level 4 Infractions of Application Requirements. Infraction points: submitting an initial license or 100 registration application that contains false or misleading information. 5.2% when points are assessed. Points will be assessed against a driller's record upon verification by the state engineer that an infraction has occurred. Points will be assessed when the state engineer becomes aware of the infraction regardless of when the infraction occurred. 5.3%, infraction notice. When infraction points are assessed against a well driller's record, the state engineer shall issue an infraction notice to the well driller. The notice shall include an explanation of the alleged violations, the date the alleged violations were discovered, and the approximate date of occurrence, the number of points assessed for each infraction, the total number of points on the well driller's record, an explanation of the adjudicative process to appeal a cease and desist order and/or infraction notice, and an explanation of how to delete points from the driller record, and any other information deemed pertinent by the state engineer. 5.4 Appeal of infractions. 5.4.1 If the infraction points do not require a hearing, a well driller may appeal an infraction within 30 days of the date the infraction notice was issued. The appeal shall be made in writing to the state engineer, and shall state clearly and concisely the disputed facts, the supporting facts, and the relief sought. If a well driller may request reconsideration of a denied appeal by requesting a hearing before the presiding officer within 20 days of the denial. If the administrative rule infractions presiding officer does not respond within 20 days after the request is submitted, then it is deemed denied. 5.5 Deleting points from the driller record. Points assessed against a well driller's record shall remain on the record, unless deleted through any of the following options. 5 on 5.1 Points shall be deleted 3 years after the date, when the infraction is noted by the state engineer, and the points are assessed against the driller's record. 5.5.2 1/2 the points on the record shall be deleted if the well driller is free of infractions for an entire year. 5.5.3 30 points shall be deleted for obtaining 6 hours of approved continuing education credits, in addition to the credits required to renew the water well driller's license. A driller may exercise this option only once each year. 5.5.4 20 points shall be deleted for taking and passing, with a minimum score of 70%, the test covering the administrative requirements and the minimum construction standards. A driller may exercise this option only every other year. 5.6 Well driller hearings. When the number of infraction points assessed against the well driller's record equals or exceeds 100, the state engineer shall submit a request to the presiding officer for a hearing. The requested purpose of the hearing shall be to determine if administrative penalties should be levied against the water well driller, including fines and probation, suspension or revocation of the water well drillers. In lieu of a hearing, the well driller may request a preliminary conference to resolve and agree upon the dispute, fines and penalties. If resolution cannot be reached at the preliminary conference, a hearing shall be held. 5.7% Lack of knowledge, not an excuse. Lack of knowledge of the law or the administrative requirements and minimum construction standards related to well drilling shall not constitute an excuse for committing a violation. 655, Vor 5. Administrative penalties. 6 Administrative penalties. Administrative penalties ordered against a licensed driller by the presiding officer following a hearing can include probation, administrative fines, license suspension and license revocation. Administrative penalties are ordered based on the severity of the infraction. See Level 1, 2, 2. From Tables 1 to 3 of subsection R 6554-5, as well as the recurrence of an infraction. The maximum administrative fine per infraction shall be capped at $1,000. 6.1 Level Y Administrative penalties. Level Y administrative penalties shall be levied against Level Y administrative infractions. See Table 1 of subsection R 655-45. The Level Y administrative penalty structure is as follows. 6.1.1. At the first conviction of Level 1 infractions, the disciplinary action for the infractions shall be probation. 6.1.2 Second conviction shall result in probation and a fine at a rate of $2.50 per infraction point. 6.1.3 Third conviction shall result in probation and an elevated fine at a rate of $5 per infraction point. 6.1.4 Fourth conviction shall result in an elevated fine at a rate of $10 per infraction point and possible suspension. 6.1.5 Continued and repeated convictions beyond the fourth conviction may result in an elevated fine at a rate of $10 per infraction point and possible suspension or revocation. 6.1.6 Fines for late well logs and abandonment logs shall be calculated separately and added to fines calculated for other infractions. For late well log infractions, the points associated with each infraction shall be multiplied by a factor based on the lateness of the well log. The infraction point multipliers are as follows in Table 5. Table 5, Tardiness of the log, infraction point multiplier, 1 to 2 weeks, 0.502 to 4 weeks, 1 to 3 months, 1.503 to 6 months, 2 6 to 9 months, 2.509 to 12 months, 3 over 12 months, 4 are 655, 2 6 to 9 months, or 655, 4. 6. Administrative penalties. 6.2 Level 2 Administrative penalties. Level 2 administrative penalties shall be levied against Level 2 administrative infractions. See Table 2 of subsection R 6554-5. The Level 2 administrative penalty structure is as follows. 6.2.1. At the first conviction of Level 2 infractions, the disciplinary action shall result in probation and a fine at a rate of $2.50 per infraction point. 6.2.2 Second conviction shall result in probation and an elevated fine at a rate of $5 per infraction point. 6.2.3 Third conviction shall result in possible suspension and an elevated fine at a rate of $10 per infraction point. 6.2.4 Continued and repeated convictions beyond the fourth conviction may result in an elevated fine at a rate of $10 per infraction point and possible suspension or revocation. 6.3 Level 2 Administrative Penalties. Level 2 administrative penalties shall be levied against Level 2 construction infractions. See Table 3 of subsection R 655-45. The Level 3 administrative penalty structure is as follows. 6.3.1 At the first conviction of Level 3 infractions, the disciplinary action shall result in probation and a fine at a rate of $5 per infraction point. 6.3.2 Second conviction shall result in possible suspension and an elevated fine at a rate of $10 per infraction point. 6.3.3 Third conviction may result in an elevated fine at a rate of $10 per infraction point and possible suspension or revocation. 6.3.4 Level 4 Administrative Penalties. The Level 4 administrative penalty shall be levied against a Level 4 application requirement infraction. See Table 4 of subsection R 655-4-5. The Level 4 administrative penalty is revocation of the license at first conviction. 6.4 Administrative Penalties, General. 6.4.1 Penalties shall only be imposed as a result of a well driller hearing. 6.4.2 Failure to pay a fine within 30 days from the date it is assessed shall result in the suspension of the well driller license until the fine is paid. 6.4.3 Fines shall be deposited as a dedicated credit. The state engineer shall spend the money retained from fines for expenses related to well drilling activity inspection, well drilling enforcement, and well driller education. 6.5 Probation, as described in subsections R 655-46, R 655-46, and R 655-46, probation shall generally be the disciplinary action imposed in situations where the facts established through testimony and evidence describe first-time infractions that are limited in number and less serious in their impact on the well owner and on the health of the aquifer. The probation period shall generally last until the number of infraction points on the well driller's record is reduced below. Administrative penalties. 70% through any of the options described in subsection R 655-4-5. 6.6 Suspension. Suspension shall generally be the disciplinary action imposed in situations where the facts established through testimony and evidence describe repeated convictions of this rule, or infractions that pose serious threat to the health of the aquifer, or a well driller's apparent disregard for this rule, or the state's efforts to regulate water well drilling. Depending upon the number and severity of the rule infractions as described in subsections R 655-46, R 655-46, and R 655-466, the state engineer may elect to suspend a well driller license for a certain period or until certain conditions have been met by the well driller. In establishing the length of the suspension, the state engineer shall generally follow the guideline that 3 infraction points is the equivalent of 1 day of suspension. A well driller whose license has been suspended shall be prohibited from engaging in regulated well drilling activity. License suspension may also result in the exaction of the well driller bond, as set forth in subsection R 655-43. A well driller whose license has been suspended is allowed to work as a registered operator under the direct continuous supervision of a licensed well driller. If the suspension period extends beyond the expiration date of the water well driller license, the water well driller may not apply to renew the license until the suspension period has run and any conditions have been met. Once the suspension period is run, and once all conditions have been met by the well driller, the suspension shall be lifted, and the driller shall be notified that the licensee may again engage in the well drilling business. The well driller shall then be placed on probation until the number of infraction points on the well driller's record is reduced below 70% through any of the options described in subsection R 655-4-5. 6.7 Revocation. Revocation shall generally be the disciplinary action imposed in situations where the facts established through testimony and evidence describe repeated convictions of this rule, for which the well driller's Utah water well license has previously been suspended. Revocation shall also be the disciplinary action taken if after a hearing the facts establish that a driller knowingly provided false or misleading information on a driller license application. A well driller whose license has been revoked shall be prohibited from engaging in regulated well drilling activity. License revocation may also result in the exaction of the well driller bond, as set forth in subsection R 655-43. A well driller whose license has been revoked is allowed to work as a registered operator under the direct, continuous supervision of a licensed well driller. A well driller whose water well license has been revoked may not apply for a new water well license for a period of 2 years from the date of revocation. After the revocation period has run, a well driller may apply for a new license as provided in section R 655-43. However, the well drilling experience required must be based on new experience obtained since the license was revoked. R 655-46. R 655-47. Adjudicative proceedings. 7.1 Designation of presiding officers. The following persons may be designated presiding officers for well driller adjudicative proceedings: assistant state engineers, deputy state engineers, or other qualified persons designated by the state engineer. 7.2 Disqualification of presiding officers. 7.2.1. A presiding officer shall be disqualified from performing the functions of the presiding officer regarding any matter in which a spouse, or a person within the third degree of relationship, to either of them or the spouse of such person. 7.2.1 is a party to the proceeding, or an officer, director, or trustee of a party. 7.2.1.2 is acted as an attorney in the proceeding, or served as an attorney for, or otherwise represented, a party concerning the matter in controversy. 7.2.1.3 knows of a financial interest, either individually or as a fiduciary, in the subject matter in controversy, or in a party to the proceeding. 7.2.1.4 knows of any other interest that could be substantially affected by the outcome of the proceeding, or 7.2.1.5 is likely to be a material witness in the proceeding. 7.2.2 a presiding officer is also subject to disqualification under principles of due process and administrative law. 7.2 These requirements are in addition to any requirements under the Utah Public Officers and Employees Ethics Act, Section 67 to 16-1 ET Sec. 7.2.4. A motion for disqualification shall be made first to the presiding officer. If the presiding officer is appointed, any determination of the presiding officer upon a motion for disqualification may be appealed to the state engineer. 7.3 Informal Proceedings. 7.3.1. All adjudicative proceedings initiated under this rule are classified as informal adjudicative proceedings. 7.3.1. The procedures for informal adjudicative proceedings initiated under this rule are set forth in this rule. 7.4 Service of Notice and Orders. As 7.4.1, hearing notices and final judgment and orders shall be served upon the well driller at the well driller's address using certified mail or methods described in Rule 5 of the Utah Rules of Civil Procedure. 7.4.2 Infraction notices, notices of approval or denial of licensing or registration or license or registration renewal, and other routine correspondence related to the division's well drilling program shall be sent to the well driller at adjudicative proceedings. The well driller's address by regular U.S. mail. 7.5 Computation of time. 7.5.1 Computation of any time period referred to in this rule shall begin with the first day following the act that initiates the running of the time period. The last day of the time period computed is included unless it is a Saturday, Sunday or legal holiday or any other day on which the division is closed, in which event the period shall run until the end of the business hours of the following business day. 7.5.2. The presiding officer for good cause shown may extend any time limit contained in this rule unless precluded by statute. All requests for extensions of time shall be made by motion. 7.6. Request for hearing. 7.6.1 A hearing before a presiding officer is permitted in a well drilling adjudicative proceeding if 7.6.1.1 the proceeding was started by an infraction notice or 6.2 the proceeding was started by a well driller request raising a genuine issue regarding 7.6.1.2.1 the denial of a license or registration renewal application or 1.6.1.2 the issuance of a cease and desist order, also known as a red tag. 7.6.2 Regardless of any other provision to the contrary, all requests for a hearing shall be in writing and shall be filed with the division to the attention of the presiding officer. 7.6.3. The request for a hearing shall state clearly and concisely the disputed facts, the supporting facts, the relief sought, and any additional information required by applicable statutes and rules. 7.6. The presiding officer shall give all parties at least 10 days notice of the date, time and place for the hearing. The presiding officer may grant requests for continuances for good cause shown. 7.6.5. Any party may by motion request that a hearing be held at some place other than that designated by the presiding officer, due to disability or infirmity of any party or witness, or where justice and equity would be best served. 7.6. A well driller at any time may withdraw the well driller's request for a hearing. The withdrawal shall be filed with the division to the attention of the presiding officer, in writing, signed by the well driller or an authorized representative, and is deemed final upon the date filed. 7.7 Filings generally. 7.1 Pascals per second filed with the division shall state the title of the proceeding and the name of the well driller on whose behalf the filing is made. R. 655. 7.2 Pascals per second filed with the division shall be signed and dated by the well driller on whose behalf the filing is made, or by the well driller's authorized representative. The signature constitutes certification that the well driller. 7.7.2.1 Read the document. 7.7.2.2 Knows the content. 7.7.2.3 To the best of the well driller's knowledge, represents that the statements are true. 7.7.2.4 Does not interpose the papers for delay, and 7.7.2.5 If the well driller's signature does not appear on the paper, authorized a representative with full power and authority to sign the paper. 7.7.3 All papers, except those submittals and documents that are kept in a larger format during the ordinary course of business, shall be submitted on an 8.5 x 11-inch paper. All papers shall be legibly hand-printed or typewritten. 7.7.4 The division may provide forms to be used by the parties. 7.75 The original of all papers shall be filed with the division with such number of additional copies as the division may reasonably require. 7.7.6 Simultaneously with the filing of any papers with the division, the party filing such papers shall send a copy to all other parties, or their authorized representative to the proceedings, by hand delivery, or U.S. mail, postage prepaid, properly addressed. 8 Motions. 7.8.1 A party may submit a request to the presiding officer for any order or action not inconsistent with Utah law or this rule. Such a request shall be called a motion. The types of motions made shall be those that are allowed under this rule, and the Utah Rules of Civil Procedure. 7.8.2 Motions may be made in writing at any time before or after the start of a hearing, or they may be made orally during a hearing. Each motion shall set forth the grounds for the desired order or action, and if submitted in writing, state whether oral argument is requested. A written supporting memorandum specifying the legal basis in support of the party's position shall accompany all motions. 7.8.3 The presiding officer may, upon the presiding officer's own initiative or upon the motion of any party, order any party to file a response or other pleading, and further permit either party to amend its pleadings in a manner just to all parties. 7.8.4 Preliminary Conference. Parties may request to appear for a preliminary conference before a hearing or before the scheduled start of a hearing, or at any time before issuing a final judgment and order. All parties shall prepare and exchange the following information at the initial preliminary conference, R 655 to 47. R 655 to 47. Including proposed areas of expertise for expert witnesses. 2. A brief summary of proposed testimony. 3. A time estimate of each witness's direct testimony. 4. Curricula vitae or resumes of all prospective expert witnesses. 5. The scheduling of a preliminary conference shall be solely within the discretion of the presiding officer. 6. The presiding officer shall give all parties at least 3 days' notice of the preliminary conference. 7. The notice shall include the date, time and place of the preliminary conference. The purpose of a preliminary conference is to consider any of the following. A. The simplification or clarification of the issues. B. The possibility of obtaining stipulations, admissions, agreements on documents, understandings on matters already of record, or similar agreements which shall avoid unnecessary proof. C. The limitation of the number of witnesses or avoidance of similar cumulative evidence, if the case is to be heard. D. The possibility of agreement disposing of all or any of the issues in dispute, or E. Such other matters as may aid in the efficient and equitable disposition of the adjudicative enforcement proceeding. 7.8.5 Consent order. If the respondent substantially agrees with or does not contest the statements of fact in the initial order, or if the parties agree to specific amendments to the statements of fact in the initial order, the parties may enter into a consent order after a preliminary conference by stipulating to the facts, fines and penalties, if any. A consent order based on that stipulation shall be prepared by the state engineer for execution by the parties. The executed consent order shall be reviewed by the presiding officer and, if found to be acceptable, will be signed and issued by the presiding officer. A consent order issued by the presiding officer is not subject to reconsideration or judicial review. 7.9 Conduct of hearings. 7.91 All parties, authorized representatives, witnesses and other persons present at the hearing shall conduct themselves in a manner consistent with the standards and decorum commonly observed in Utah courts. Where such decorum is not observed, the presiding officer may take appropriate action including adjournment if necessary. 7.9.2 The presiding officer shall conduct the hearing, make all decisions regarding admission or exclusion of evidence or any other procedural matters, and R. 655-4-7 Adjudicative proceedings. Have an oath or affirmation administered to all witnesses. 7.10 Rules of evidence in hearings. 7.10.1 Discovery is prohibited, but the division may issue subpoenas or other orders to compel production of necessary evidence. 7.10.2 A party may call witnesses and present oral, documentary and other evidence. 7.10.3 A party may comment on the issues and conduct cross-examination of any witness as may be required for a full and true disclosure of all facts relevant to any issue designated for hearing, and as may affect the disposition of any interest which permits the person participating to be a party. 7.10.4 A witness testimony shall be under oath or affirmation. 7.10.5 Any evidence may be presented by affidavit rather than by oral testimony, subject to the right of any party to call and examine or cross-examine the affiant. 7.10.6 Relevant evidence shall be admitted. 7.10.7 The presiding officer's decision may not be based solely on hearsay. 7.10.8 Official notice may be taken of all facts of which judicial notice may be taken in Utah courts. 7.10.9 All parties shall have access to public information contained in the division's files and to all materials and information gathered in the investigation, to the extent permitted by law. 7.10.10 No evidence shall be admitted after completion of a hearing or after a case is submitted on the record, unless otherwise ordered by the presiding officer. 7.10.11 Intervention is prohibited. 7.10.12 A well driller appearing before the presiding officer for a hearing may be represented by a licensed attorney. The water well drilling specialist shall present evidence before a presiding officer supporting the state engineer's claim. At the state engineer's discretion, other division staff or a representative from the office of the attorney general may also present supporting evidence. 1. Preemptive hearing. Testimony and argument at the hearing shall be recorded electronically. The division shall make copies of electronic recordings available to any party upon written request. The fee charged for this service shall be equal to the actual costs of providing the copy. The division is not responsible to supply any party with a transcript of a hearing. 7.11.2 If any party shall cause to be produced a transcript of a hearing, a copy of said transcript shall be filed with the division and provided to all other adjudicative proceedings. Parties. By order of the presiding officer and with the consent of all parties, such written transcript may be deemed an official transcript. 7.11.3 Corrections to an official transcript may be made only to conform it to the evidence presented at the hearing. Transcript corrections, agreed to by opposing parties, may be incorporated into the record, if and when approved by the presiding officer, at any time during the hearing, or after the close of the adjudicative proceeding. The presiding officer may call for the submission of proposed corrections, and may determine the disposition at appropriate times during the proceeding. 7.1 2 Procedures and standards for orders. 7.12 If the well driller attends the hearing, the presiding officer shall issue a final judgment and order. 7.12.2 The presiding officer may issue a default order if, after proper notice, the well driller fails to attend a hearing scheduled by the presiding officer. 7.12.3 Within a reasonable time after the close of a well driller adjudicative proceeding, the presiding officer shall issue a written and signed final judgment and order, including 7.12.3.1 A statement of law and jurisdiction. 7.12.3.2 A statement of facts. 7.12.3.3 An identification of the confirmed infractions. 7.12.3.4 An order setting forth actions required of the well driller. 7.12.3.5 A notice of the option to request reconsideration and the right to petition for judicial review. 7.12.3.6 The time limits for requesting reconsideration or filing a petition for judicial review, and 7.12.3.7 Other information the presiding officer deems necessary or appropriate. 7.12 The presiding officer's final judgment and order shall be based on the record, as defined in this rule. 7.12.05 A copy of the presiding officer's final judgment and order shall be promptly mailed to each of the parties. 7.12.6 A well driller who fails to attend a hearing waives any right to request reconsideration of the final judgment and order, per subsection R. 655-47, but may petition for judicial review per subsection R. 655-47. 13. Reconsideration. 7.13.1 Within 14 days after the presiding officer issues a final judgment and order, any party may file a written request for reconsideration, stating the specific grounds upon which relief is requested. R. 655-47. R. 655-47. Adjudicative proceedings. 7.13.2 Unless otherwise provided by statute, the filing of a request for reconsideration is not a prerequisite for seeking judicial review of the order. 7.13.3. The request for reconsideration shall be filed with the division to the attention of the presiding officer, and one copy shall be mailed to each party by the party filing the request. 7.13.4. The presiding officer may issue a written order granting or denying the request for reconsideration. It is not required that the written order explain the grounds for the presiding officer's decision. 7.13.5. If the presiding officer does not issue an order granting a request for reconsideration within 14 days after the date it is filed with the division, the request shall be considered denied. 7.14. Amending administrative orders. 7.14.1. On the motion of any party or of the presiding officer may amend a final judgment and order for reasonable cause shown, including a clerical mistake made in the preparation of the order. 7.14.2. A motion by any party to amend an order shall be made in a reasonable time, and, if to amend a final judgment and order, not more than 3 months after the final judgment and order was issued. 7.14.3. The presiding officer shall notify the parties of the receipt and consideration of a motion to amend an order by issuing a notice. The notice shall include a copy of the motion. 7.14.4. Any party opposing a motion to amend an order may submit information within the time period to be established by the presiding officer's notice of the motion. 7.14.5. After considering a motion to amend an order and any relevant information received from the parties, the presiding officer shall advise the parties of the determination. If the presiding officer determines that the order shall be amended, the presiding officer shall issue the amended order to all parties. 7.15. Setting aside a final judgment and order. 7.15.1. On the motion of any party or on a motion by the presiding officer may set aside a final judgment and order on any reasonable grounds, including the following. 7.15.1.1. The well driller was not properly served with an infraction notice. 7.15.1.2. A rule or policy was not followed when the final judgment and order was issued. 7.15.1.3. Mistake, inadvertence, excusable neglect. 7.15.1.4. Newly discovered evidence which by due diligence could not have been discovered before the presiding officer issued the final judgment and order. Or 7.15.1.5. Fraud, misrepresentation or other misconduct of an adverse party. 7.15.2. A motion to set aside a final order shall be made in a reasonable time, and not more than 3 months after the final judgment and order was issued. 7.15.3. The presiding officer shall notify the parties of the receipt and consideration of a motion to set aside a final order by issuing a notice to all parties, including a copy of the motion. 7.15.4. Any party opposing a motion to set aside a final order may submit information within the time period to be established by the presiding officer's notice of the motion. 7.15.4. After consideration of the motion to set aside an order and any information received from the parties, the presiding officer shall issue an order granting or denying the motion, and provide a copy of the order to all parties. 7.16. Judicial Review. 7.16.1. Pursuant to Section 73.3.14, a final judgment and order may be reviewed by trial de novo by the District Court. 7.16.1.1 in Salt Lake County. Or 7.16.1.2 in the county where the violation occurred. 7.16.2. A well driller shall file a petition for judicial review of a final judgment and order within 20 days from the day on which the order was issued, or if a request for reconsideration has been filed and denied, within 20 days of the date of denial of the request for reconsideration. 7.16. The presiding officer may grant a stay of an order or other temporary remedy during the pendency of the judicial review on the presiding officer's own motion, or upon the motion of a party. The procedures for notice, for consideration of motions and for issuing a determination shall be as set forth for a motion to set aside a final judgment and order. 655.4.7. or 655.4.8. License and operator registration renewal. 8.1. Well driller and pump installer licenses. The division will mail to each licensed well driller and pump installer a notice packet to renew the license about 30 days before the expiration of the license. Failure to receive the notice does not relieve a licensee of an obligation to file application and pay the fee for renewal in a timely manner. A well driller shall notify the division of any change in mailing address within 30 days after the change. 8.1.1. Well driller licenses and pump installer licenses shall expire and be renewed according to the following provisions. A. The licenses of well drillers and pump installers, whose last name begins with A through L, shall expire at 12 midnight on June 30 of odd-numbered years. B. The licenses of well drillers and pump installers, whose last name begins with M through Z, shall expire at 12 midnight on June 30 of even-numbered years. C. Drillers and pump installers who meet the renewal requirements set forth in subsection R. 655.4.8, on or before the expiration deadline set forth in subsection R. 655.4.8, shall be authorized to operate as a licensed well driller or pump installer until the new license is issued. If a licensee does not complete the renewal requirements by the license expiration date, the license will become inactive, and the licensee must cease and desist all regulated work until the license has been renewed. D. Licensees must renew their licenses within 24 months of the license expiration date. Licensees failing to renew within 24 months of the license expiration date must reapply for a license, meet all the application requirements of subsection R. 655.4.3, if reapplying for a well driller's license, or subsection R. 655.4.3, if reapplying for a pump installer's license, and provide documentation of 12 hours of continuing education, according to the requirements of subsection R. 655.4.8 obtained within the previous 24 months. 8.1.2 Applications to renew a license must include the following items. A. Payment of the license renewal fee determined and approved by the legislature. B. Written application to the state engineer. C. Documentation of continuing well driller bond coverage in the amount of $5,000 penal bond for the next licensing period. The form and conditions of the well driller bond shall be as set forth in subsection R. 655.4.3. Allowable documentation can include bond continuation certificates and CD statements. D. As applicable to the type of license, proper submission of all start cards, official well driller reports, also known as well logs, pump installer reports, also known as pump logs, and well abandonment reports for the current licensing period. E. Documentation of compliance with the continuing education requirements. R655-48. License and operator registration renewal, described in subsection R655-48. Acceptable documentation of attendance at approved courses must include the following information: the name of the course, the date it was conducted, the number of approved credits, the name and signature of the instructor, and the licensee's name, for example, certificates of completion, transcripts, attendance rosters, or diplomas. Licensees are advised that the state engineer will not keep track of the continuing education courses each licensee attends during the year. Licensees are responsible to acquire and then submit documentation with the renewal application. 8.1.3 License renewal applications that do not meet the requirements of subsection R655-48 by June 30 of the expiration year or which are received after June 30 of the expiration year will be assessed an additional administrative late fee determined and approved by the legislature. 8.1.4 Restricted, conditioned, limited, or denied renewal applications. 8.1.4.1 The state engineer may renew a license on a restricted, conditional, or limited basis if the licensee's performance in compliance with established rules and construction standards show the scope of the licensee's permitted activities should be reduced or that the licensee requires strict supervision during a probationary period. 8.1.4 The restricted, conditional, or limited license shall state the restrictions, conditions, or limitations placed on the licensee's regulated activity, whether the restrictions, conditions, or limitations are permanent or time-limited, and the requirements, if any, which must be met for the license to be reissued without restrictions, conditions, or limitations. 8.1.4.3 The state engineer may deny an application to renew a license if there has been a violation of this rule or section 73.325 that casts doubt on the competency of the licensee or the licensee's willingness to comply with the well drilling administrative requirements or construction standards. 8.1.4.4 Within 30 days of a license renewal application being denied, or a license being renewed on a restricted, conditioned, or limited basis, a licensee may appeal the action by requesting a hearing according to section R655-47. 8.1.4.5 The restrictions, conditions, or limitations on a license, or the denial of a license, shall remain effective during the pendency of the well driller or pump installer adjudicative proceeding. 8.2 Continuing education. 8.2.1 During each license period, licensed well drillers and pump installers are required to earn at least 12 continuing education credits by attending training sessions approved, sponsored, or sanctioned by the state engineer. Drillers and pump installers who do not renew their licenses, but who intend to renew within the following 24-month period, allowed in subsection R655-48, are also required to earn 12 continuing education credits. 8.2.2 The state engineer will develop criteria for the training courses, approve the courses that can offer continuing education credits, and assign the number of credits to each course. The number of state engineer shall assign the number of continuing education credits to each proposed training session based on the instructor's qualifications, a written outline of the subjects to be covered, and written objectives for the session. Licensees wishing continuing education credit for other training sessions shall provide the state engineer with all information it needs to assign continuing education requirements. 8.2.4 Licensed drillers must complete a state engineer-sponsored administrative rules for well drillers and pump installers review course or other approved rules review once every 4 years. 8.2.5 CE credits cannot be carried over from one licensing period to another. 8.3 Operators registration. 8.3.1 Drill rig and pump rig operator registrations shall expire at the same license of the well driller or pump installer by whom they are employed. Operators who meet the renewal requirements set forth in subsection R655-48 on or before 12 midnight June 30 of the expiration year shall be authorized to act as a registered operator until the new registration is issued. Operators must renew their registrations within 2004 months of the registration expiration date. Operators failing to renew within 24 months of the registration expiration date must reapply for an operator's registration and meet all the application requirements of subsections R655-43 and R655-43. 8.3.2 Applications to renew an operator's registration must include the following items. A. Payment of the registration renewal fee, determined and approved by the legislature. B. Written application to the state engineer. 8.3.3 Registration renewal applications that do not meet the requirements of subsection R655-48 by the June 30 expiration date, or that are received after the June 30 expiration date, will be assessed an additional administrative late fee determined and approved by the legislature. 8.4 Shallow water well constructor licenses. The division will mail to each licensed shallow water well constructor a notice packet to renew their license about 30 days before the expiration of the license. Failure to receive the notice does not relieve a licensee of the obligation to file application and pay the fee for renewal in a timely manner.